Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, you know, one of the things that we actually take great pride here at Washington Gun Law is that we don't tell you how to think, but we do give you a lot of stuff to think about. We like to keep it right down the middle. And so when I see a case where it would be quick for us to sit there and go, hey, this is great. Yeah, let's do this. We always have to stop and do one of these consider this. And that's what we're going to do with today's video, because there's a case kicking around on the shadow docket right now of the United States Supreme Court. Has nothing to do with Second Amendment rights whatsoever, but it does have a lot to do with Fourth Amendment rights. And if this case were to go the wrong way, we're going to have a serious one of these consider this. So today, let's spend a few minutes and let's talk about the most dangerous case to your Second Amendment rights, and no one's talking about it. Okay, America, we are out here in the beautiful Palouse region of Washington State, not far from Pullman, Washington. Listen, I'm going to talk to you about a case that's kicking around on the shadow docket of the United States Supreme Court. The case we're talking about today is Gnome versus Perdomo. It comes out of the Ninth Circuit. Now, in a nutshell, this was a lawsuit that was filed against the United States government on immigration enforcement in Los Angeles County, where ICE agents essentially were showing up at Home Depots and other places and merely contacting people because, you know, they look the part. The trial court, of course, enjoined it. It was then appealed on an emergency basis to the Ninth Circuit, who upheld that injunction. Then the United States government filed an emergency appeal with the United States Supreme Court to stay that injunction. That injunction was stayed by no order whatsoever other than a docket entry earlier this month. However, at the time that the stay was entered, 3 justices dissented. You can imagine which 3 those were. And only one judge wrote a concurring opinion. That was Justice Kavanaugh. And what we're going to be focusing on today is Justice Kavanaugh's reasoning because, well, it's kind of problematic. Okay, now to understand what we're talking about today, first let's understand what we're not talking about. We're not talking about the Second Amendment. We're thankfully not talking about the First Amendment, but we are talking about the Fourth Amendment. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing place to be searched and the persons or things to be seized. Now, probable cause is a standard that if we take a look at it here on the scales of proofs, probable cause is a standard that law enforcement needs in order to effectuate an arrest. What we're talking about actually is the lower burden of proof, which is merely to temporarily detain or seize an individual for a brief investigatory period, or what sometimes is called a Terry stop. That only needs to be supported by a reasonable and articulable suspicion of criminal activity. Now, this also gets down to what is sometimes called profiling, and there is a litany of case law, depending on what state you're in, that either allows it or does not allow it. The reason law enforcement profiles is, well, because it works. Now, as the court summarized what the United States Immigration and Custom Enforcement was doing, it was, not surprisingly, given these extraordinary numbers, U.S. immigration officers have prioritized immigration enforcement in the Los Angeles area. The government sometimes makes brief investigative stops to check the immigration status of those who gather in locations where people are hired for day jobs, who work or appear to work in jobs such as construction, landscaping, agriculture, or car washes that often do not require paperwork and are therefore attractive to illegal immigrants and who do not speak much, if any, English. And then in describing this brief investigative stop that government can do in the event of a reasonable articulable suspicion, Justice Kavanaugh points out, to stop an individual for a brief questioning about immigration status, the government must have reasonable suspicion that the individual is illegally present in the United States. Reasonable suspicion is a lesser requirement than probable cause and considerably short of the preponderance of evidence standard. Whether an officer has reasonable suspicion depends on the totality of the circumstances. Okay, and then we're going to go through all of the criteria that ICE was using. And I'm not being critical of it, and you're all going to be nodding along and saying, yes, all of this makes sense, okay? Here's the criteria that ICE is using in this particular situation. Here, those circumstances include that there is an extremely high number and percentage of illegal immigrants in the Los Angeles area, that those individuals tend to gather in certain locations to seek daily work, that those individuals often work in certain kinds of jobs, such as day labor, landscaping, agriculture, and construction, that do not require paperwork and therefore are especially attractive to illegal immigrants, and that many of those illegally in the Los Angeles area come from Mexico or Central America and do not speak much English. And you sit there and go, whoa, 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 wait a second. Doesn't that seem a little bit like racial profiling? I don't know if it necessarily is racial profiling. Justice Kavanaugh actually explains it away this way. To be clear, apparent ethnicity alone cannot furnish reasonable suspicion. Under this court's case law regarding immigration stops, however, it can be a relevant factor when considered along with other salient factors. And then again, in kind of one of those duh moments, Justice Kavanaugh states, under this court's precedents, not to mention common sense, those circumstances taken together can constitute at least reasonable suspicion of illegal presence in the United States. But now I want you to consider this, okay? The first thing I want you to consider is recent statements by Justice Thomas in which he said that maybe precedent doesn't have as much value. Now, there are two very specific cases that come to mind, one of which we all learn in law school. Of course, that's the case of Terry v. Ohio. Now, of course, the other case that deals specifically in the immigration context is the matter of United States versus Brignani Ponce, where it basically stated that you just couldn't have roving patrols of people just stopping any Hispanic-looking individual near the border. That was not tantamount to a reasonable and articulable suspicion. But here's the other consider this. What happens when the shoe's on the other foot? What happens suddenly when we have a different individual in the White House, when we have a different Department of Justice, when we have a different type of ATF, one that perhaps maybe resembles last administration's ATF. And instead of going after illegal immigrants, they now are trying to go after lawful and responsible gun-owning Americans. And they want to use similar criteria. Where are they most likely to hang out? What are they most likely to look like? What are they most likely to do? And suddenly you have ATF agents contacting every middle-aged white male Christian who also happens to be a patriot. Because the weaponization of government in that exact fashion to go after those exact people, well, that's already been done. That would just be another page in an already written playbook, wouldn't it? So listen, we're going to carefully follow this case, and we don't know exactly where the Supreme Court's going to come down on this, but I will tell you that Justice Kavanaugh's reasoning, if expanded across other constitutional dimensions here, has a particular problem for all of us. Okay, the case once again is Gnome v. Perdomo. We're going to link it up down below so you could read Justice Kavanaugh's concurring opinion as well as the dissenting opinions. Now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do that is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.